Your Honor?
Yes, thank you.
If we have questions, please write them down.
Yes, but there hasn't been any testimony yet, so, all right? So we'll get there, don't worry, but the short answer is yes.
But I do have two questions about just what you said. Is that
Not at this point,
okay?
okay? Save those thoughts. You can write them down, and we'll talk about it, okay? All right, please.
Thank you, Judge. Good afternoon, everybody. My name is Alex Garcia, and along with Mr. Todd Baker, we have the distinct honor of representing Ms. Sompun Ruchimora in this accident. A driver of a car isn't allowed to needlessly endanger the public. A driver of a car has to watch where she's going and see what there is to be seen. A driver has to pay attention at all times. And if she allows her attention to wander, and as a result she hurts someone, she's responsible for that harm. Now let me tell you the story of what happened in this case. Let me take you back to February 26, 2010. It's a Friday afternoon. It's the height of rush hour at 4:49 p.m. We're in Miami-Dade County on I-95 headed southbound, just nearing the exits for Miami Gardens. There are 4 lanes of traffic. It's congested, but the traffic is moving at a normal pace. People are on the way home from work, having picked up their children from school or daycare. A 25-year-old young woman is traveling southbound on I-95. For some unknown reason, she wasn't paying attention to the roadway and the traffic ahead of her, and failed to notice that the traffic was slowing down and stopped, and she smashes into the back of that vehicle. A woman inside the car that she ran into was injured. The doctor had to surgically remove bone from 3 of her vertebrae to relieve the pressure on her spinal cord, and then fuse the vertebrae together with 2 metal rods and 6 screws. She also had to undergo 4 injections into her spinal cord, a nerve avulsion, and another 2 injections into her joint, her pelvis. That woman was my client, Sompun Ruchimora, and the driver of the vehicle, who wasn't paying attention, was the defendant, Ms. Bernice. Now let me tell you who we are suing and why. We're suing Bernice Grullon for 3 reasons. The first reason we're suing Bernice Grullon is she chose not to look where she was going. She chose not to pay attention on February 26, 2010, as she was heading southbound on I-95. When a driver doesn't look, by the time she looks back at the road, it can be too late to avoid hitting something. In this case, because Bernice Grullon wasn't looking, she didn't see that the traffic ahead of her had stopped until it was too late to slow down. Bernice Grullon should have kept her eyes on the road. If she'd done that, she would have seen the traffic had stopped with plenty of time to slow down and avoid this collision. If she'd done that, we wouldn't be here today. The second reason we're suing Bernice Grullon is that she claimed that the accident wasn't her fault. When we sued Bernice Grullon,
Your Honor, this is not appropriate for a
All right. Do it as not as argument, but as a statement of what you believe the facts are going to show, please.
the evidence is going to show that in the answer to the lawsuit that was filed against her,
Judge, again, I object. It's not relevant to the issue. The jury's going to decide, and I have an appropriate motion.
All right. Overruled.
in the answer to the lawsuit that we filed against her, she claimed that my client failed to use reasonable care at the time of the accident, despite the fact that she was the one that rear-ended my client. In the document that we call request for admissions, she denied she was negligent at all, even to some degree.
Same objection, Your Honor.
Overruled.
We had to take Ms. Bernice Grullon's deposition and then file a motion before this court, before the court finally ruled on the issue and found that she was liable for this accident, that she was negligent.
Your Honor.
The third reason we're suing Bernice Grullon is that she claims that there was almost no damage to either vehicle in the crash. And as a result, Ms. Sompun Ruchimora couldn't have been injured. She claims that the damage, almost no damage. Now here's the problem. Nobody took pictures of the vehicles after the accident. Not my client, not Miss Grullon. My client's vehicle was repossessed a couple months later, and Miss Grullon eventually sold her vehicle. The evidence is going to show you that the defendant claims that there was almost no damage to either car, while my client claims there was quite a bit of damage to her car. So you will need to weigh the credibility of Miss Sompun Ruchimora and Miss Bernice Grullon. So we needed to take the deposition. So before we came to trial, we needed to know who was telling the truth. So we took the deposition of the responding police officer, Trooper Alexis O'Tonnell, who responded to the scene, and you will hear his testimony, and he will tell you that he estimated that the damage to the car was moderate, not minor. And he described moderate as the bumper on the back of the car was broken. It wasn't just scuffed or scratched. Then we took the deposition of Miss Bernice Grullon herself. Now, according to Miss Grullon, the damage was so minimal that it looked like a perfect car. She even brought a picture of the car to the deposition, which she took when she posted the car on Craigslist to get it sold. And sure enough, the photograph that she brought to the deposition, and you'll get to see that photograph in the evidence, looked like a perfect car. No scratches, no scuffs, no dents, no crushing. It looked perfect. She actually said whatever damage was done to the car, you can see in the picture. Now this picture was taken nearly 2 years after the accident. So we asked her, between the time of the accident that was spoken about on I-95 and the day you sold the car, you had no repairs done to it at all. From the day of the accident to the day she sold it 2 years later, we asked her, did you do any repairs to it at all? And the evidence is going to show you that she responded, I don't think so, no. So we checked out her story and discovered that after our crash of February 26, 2010, she was involved in another accident 9 months later, on November 29th of 2010, with front-end damage. And then another accident 11 months later, on January 13th, 2011, and then possibly a third crash. And you're going to be able to see the actual repair estimates of the vehicles. And the evidence is going to show you that the vehicle was actually fixed at least 2 times from the date of the accident, our accident, to the day that she showed that picture in her deposition. And she claimed that no repairs had been done to that car. I don't think so, no. And when you're listening to the testimony, you can consider the credibility of the defendant as you hear the testimony is presented to you. So let's talk about Ms. Sompun Ruchimora's injuries. Sompun Ruchimora will testify that immediately after the accident, she felt pain in her back. As a matter of fact, she describes it as her entire back felt numb. She drove herself to Jackson North, where she was x-rayed and given some painkillers. On the same day of the accident, she followed up with Dr. Kumani, who's a chiropractor, who gave her a conservative course of physical therapy for several months. And because she wasn't getting better, he sent her for an MRI, and they found that she had disc herniations on her lumbar spine, the lower part of her back. Now you will hear, and there's no dispute, that Ms. Ruchimora had a pre-existing congenital condition called spondylolisthesis. Basically, she was born with a weakness in her spine where the vertebrae can slip forward and over the bone below. About 5% of people are born with this weakness, and most never have symptoms or need treatment. However, it did make Ms. Ruchimora, the evidence will show you, it did make Ms. Ruchimora more susceptible to injury in this traumatic crash. Now, Ms. Ruchimora followed up with pain management doctor by the name of Nelusha Fernandez, who gave her 2 lumbar fasten injections on 2 separate dates. The injections you will hear from Ms. Ruchimora that helped for a while, and then the pain came back. She was then sent to an orthopedic surgeon by the name of Dr. Amos Duray, who recommended surgery. She was scared and said, no way, and she looked for other options. She was seen by another pain management doctor by the name of Danny Driscoll, who did another set of injections called medial branch blocks. And again, they provided some relief, but then the pain came back. So she was scheduled for a minimally invasive procedure called an avulsion of the medial branch nerves, as well as another injection. The procedure, again, provided temporary relief, but then the pain came back worse than ever. So she was sent for another MRI. The results showed her condition was getting progressively worse in her lumbar spine, in her lower back. So she was sent to another orthopedic surgeon for a second opinion, Dr. Edward Chung. And Dr. Edward Chung recommended surgery, and she finally decided to go ahead with it. On May 25th, 2012, she was admitted to Delray Medical Center, where they performed a 2-level lumbar laminectomy and spinal fusion. It's a procedure where they remove bone from 3 of the vertebrae to decompress the spinal cord, and then 2 rods are placed across the vertebrae, and 6 screws are put right into the bone of the vertebrae to fuse those vertebrae together. She spent 5 days in the hospital before she was finally discharged, and though the surgery was successful in relieving the radiating pain that went down into Ms. Ruchimora's legs, she continued to have back pain. Dr. Chung, the orthopedic surgeon, concluded that the pain is a chronic condition. She tried to live with the pain, but 4 years later, she couldn't take it anymore, and she went to see another orthopedic surgeon, Dr. Valerio, who recommended another surgery. Now you're going to hear that Dr. Valerio was actually an orthopedic surgeon that was hired by the law firm, by our law firm, to be an expert in the case, to review the medical records and be able to talk to you about those medical records. But when Dr. Valerio examined Ms. Ruchimora, he actually became her treating physician because he recommended another surgery to her back. And when he recommended the surgery, again, she said she was scared, no way, I don't want the surgery. And he went ahead and ended up doing some more injections, and they're called sacroiliac joint injections. And again, those provided some relief, but the pain came back. Now you're going to hear from an engineer that was hired by the defense called Dr. Scott, who will testify that this crash turned to causing injuries. So we took his deposition to find out how he came to that conclusion. He will tell you that he was able to inspect the defendant's car, Ms. Grullon's car, a Mitsubishi Lancer, 4 years after the accident. He found that the metal rebar underneath the front bumper was bent. And as a result, he did calculations and determined whether the forces needed to damage the rebar were sufficient to injure Ms. Ruchimora. Unfortunately, Dr. Scott didn't know that the vehicle had been involved in another 3 accidents after our crash. And as a result, he will admit he doesn't know whether the rebar that he inspected had been previously replaced. Despite this, Dr. Scott sticks to his guns and sticks to his opinion. Now, you're also going to hear from another expert that the defense hired, an orthopedic doctor by the name of Dr. Warren Grossman. Now, Dr. Grossman is an orthopedic surgeon who actually examined Ms. Ruchimora on behalf of the defense. And unlike the defense's engineer, he stated that our crash contributed to Ms. Ruchimora's need for the surgery. Basically, he stated that without this collision, she would have needed the surgery to her lower back. Despite that fact, the defendant's own hired orthopedic surgeon says that without this accident, she would not have needed this surgery. Their engineer, Dr. Scott, is not a medical doctor, sticks to his guns and says, no, accident could have caused the injury. And then when he's asked why her symptoms changed following the crash, why did Ms. Ruchimora's symptoms change after this crash, Dr. Scott has no explanation. No. You're going to hear from several experts that the defense is going to present to you, and not one of them has an explanation as to what caused Ms. Ruchimora's injuries aside from the crash of February 26, 2010. The only time Ms. Ruchimora was involved in a crash prior to this one was in 2008. She will testify that in that accident, she hurt her upper back, and she was taken to Holy Cross Hospital, where they did a thoracic x-ray, an x-ray on her upper back. However, within a few days, she was recovered. She didn't have any further treatment. But most importantly, the defense agrees that the 2008 crash had no effect on the 2010 crash. Both of their experts, Dr. Grossman and Dr. Scott, both agree that she had no permanent injury in that 2008 crash. So yes, she had a prior crash where she hurt her back, but even their own experts agree it wasn't permanent and had no effect on this next one. This case boils down to who is telling the truth. Is it Ms. Ruchimora or is it Ms. Grullon? And you will need to decide whether this accident, the severity of this accident, was sufficient to cause the injuries that Ms. Ruchimora treated for. And when you're making that decision, you will need to decide, and you will be able to consider the credibility of the witnesses and make a decision as to whether you believe Ms. Ruchimora is telling you the truth about the severity of the accident, or whether Ms. Grullon is. Ladies and gentlemen, I feel confident that once we've heard all the evidence in this case, we'll turn a verdict that is just and fair in favor of my client, Ms. Ruchimora.
All right, thank you, Mr. Garcia.
Judge, you get a reserve on the motions I may have? Would you reserve on the motion I have?
Sure.
Good afternoon, everybody. I'm going to probably age myself. There was an old radio commentator named Paul Harvey. He used to say, and now for the rest of the story. Okay, that's how he used to do his commentary at like 5 o'clock every night on the radio. It's taken a number of years, but I think I finally agree with the plaintiff's counsel in this case that this case does come down to credibility. Okay? We got up here and told you that this accident happened on I-95 and the cars smashed together. Okay? Dr. Scott, the biomechanical expert, and biomechanical experts, they measure forces that occur to bodies in accidents. They can look at vehicles and look at speeds and determine how fast the vehicle was going at the time of the collision. They also have an expert, and we'll probably read portions of his expert. They went to North Dakota to find this expert, who's a biomechanical expert, who agrees with Dr. Scott that the speed of the collision.
Objection, Your Honor, may we approach?
Yes, sir.
Sorry. Trying to do this.
All right, I got you. The objection is overruled. We'll get to that all later. Thank you.
Okay? All right. As I was saying, their expert and my expert both agree this was a 7-mile-per-hour impact. 7 miles per hour. So you can use your good old common sense while you listen to the evidence in this case and keep that in mind. What you heard, it was a smash. What's more disturbing, though, is the testimony. He said you have to judge the credibility of the people in this case. Okay? The plaintiff is the #1 person whose credibility you have to take into account. And she appears at a doctor's office on you'll have these records and evidence, but I want you to take note, if you can, of these to this date. 7/30 of 2010, she shows up to see an orthopedic surgeon by the name of Dr. Joshua Appel. And you'll hear that whenever you go in and see a doctor, they take what's called a history. Tell us what's wrong with you. Tell us why you're here. Tell us what happened. And this is the history she gives Dr. Appel. I was rear-ended by another vehicle and my car was towed. That's what she tells her doctor. But it doesn't stop there. All right. She also tells another physician that she sees, Dr. Chung, that she was transported from the scene of this accident by ambulance. That's not true either. So, please, credibility has absolutely everything to do with this case. All right? client's negligence. She caused the accident. Okay? The plaintiff has the burden of proof. There are no photographs that show this smash of the vehicle. In this case, the burden vehicle. There's no repair estimates of that vehicle that they're going to bring in. But what's interesting is that there is a disinterested party in this case. Okay? The plaintiff was driving a GMC at the time of this accident that was repossessed, not because of anything to do with the accident, but a month after this accident, her car gets repossessed by the bank. Okay, and here's where your common sense comes into play. Does any of you have leased a car or financed a car?
Objection, Your Honor, to any reference to anything we have done.
Sustain.
The bank takes the car back, they send her a bill for the payments that are owed, and they know that there's no damage to the car. They don't send her any bill for damage to the car that they claim was caused in this accident. That's very tough, because again, that's somebody who has absolutely no interest in this case at all. But it gets better, because the bank sells the car. We go and depose the individual who bought the car. The individual says there wasn't a scratch on this thing. No damage whatsoever. It doesn't stop there. There's another third party to hear from that inspected that vehicle for the person who was buying it. Okay, after it had been repossessed, it had never been repaired. And that person inspects the car and says, there wasn't a scratch on it. No damage to it at all. Okay. The plaintiff is being followed at the time of this, I'm sorry. My client has a friend now, Natalie Fionis, who's a lawyer. She's a plaintiff's lawyer from Orlando.
Objection, Your Honor, relevance.
Testimony in this case.
Overruled.
All right. And you'll hear that everybody takes this stand, takes an oath to tell you the truth under the penalty of perjury. But an attorney takes an additional oath before they become an attorney.
Objection, Your Honor, improper bolstering.
All right, sustain.
You'll hear her qualifications. She rolls up on the scene after it happened. Plaintiff doesn't complain of any injuries. You would think somebody whose back is completely numb may have said something to somebody. Okay, as far as the witness asking her if she's okay, she said she was fine. All right, and she looks at the vehicles and she doesn't see any damage to it. It's such a non-event that nobody thinks to take any pictures of it. All right.
Objection, argumentative, Your Honor.
Nobody took any pictures.
Overruled.
So then the next thing that goes to the credibility of the plaintiff is she goes to the emergency room. Okay, from the scene she drives herself to the emergency room. They examine her. Her exam is completely normal. And what's important is you just heard they took bones out of her back, and that she had, you're going to hear that she has all these nerve issues and strength issues. At the emergency room, they diagnosed her with what we call strain or sprain. They checked her nerve function. Yeah, you see some dermatomes back there that we use a chart on that shows how nerves run out of the arms and the backs and into, out of your neck into your arms and from your back into your legs. And that examination at the emergency room was completely normal. Normal sensation, normal reflexes, the old rubber hammer on the knee, okay, normal muscle strength, all things that doctors look for if you had traumatically injured your back or had a herniation. But remember, she's going to tell you that her back was completely numb. No finding of that whatsoever by the uninterested emergency room personnel who see her on the day of the accident. They take x-rays. You heard about this spondylolisthesis that she has, this pre-existing condition. They looked at it on the x-rays. There's nothing new there, nothing acute. And that's important because they want, at the end of the day, they're asking for an injury that was caused on the day of this accident at the emergency room doctor's office, which they're trained for. The next thing that happens, the plaintiff under oath, what we do is we take what's called depositions, and we'll hear about these. They're sworn statements of people that are taken under oath, just like they do in a courtroom, that we do outside of court, so we know what everybody's going to say before we get here. And we took the plaintiff's deposition, had her swear to tell the truth. She had her attorneys there to represent her, Nothing was lost in the translation, okay? She was provided every opportunity to tell us if she didn't understand the question, if she was confused about a question. And here's one of the answers she gave us. She told us that the emergency room personnel referred her to the chiropractor that she ended up going to 3 days after the accident. Absolutely, completely untrue.
Objection, argumentative, Your Honor.
Sustained.
The evidence in this case would be that that is not the case.
Objection, argumentative, Judge.
The evidence.
All right, overruled.
You will have the discharge summary from the hospital that tells her to go to a primary care physician. No, you'll hear that no hospital, the evidence in this case would be from even their own doctors, that they don't know of any hospital that refers people to a chiropractor for the emergency. It just doesn't happen. They're not medical doctors. And facilities don't do that. Yet she insisted that it was the hospital that sent us to the chiropractor. I'm like, okay, so what's the big deal? 3 days after she shows up, and this record we have, it's a doctor's name. And what we call, we also hear we call it a letter of protection. And on that day, she shows up and her attorney's name's on there, 3 days after the accident. And it's our contention that this is how she got to the chiropractor. So,
Objection, Your Honor. Did we approach?
Please continue.
all right.
I reserve on motion, Your Honor.
Yes, sir.
You get to use your common sense. The attorney's name's on this form. First time she was to see-
Mr. Rob, what's the, please.
I'll move on. But in addition to telling her doctors that she was transported by BMS, which again, the records will show is not the case, that her car was totaled, which again, is not the case. She had her son appeared for a deposition, and he told the same story, that her car was totaled. Under oath, Mr. Bushman took his deposition. He said, "Oh yeah, my mom told me about that accident. Her car was totaled." Okay, so yes, credibility, by all means, is a huge issue in this case. She also tells some doctors she was hit twice. We don't know where that comes from. We'll see that record. And I submit to you, as you listen to the evidence, you know when the truth being told, when you listen to the evidence, when it's consistent, it makes sense. It's an easy way to tell when you're not being told the truth. The back surgery that she has, okay? The back surgery is done 2 years and 2 months after this accident. 2 years and 2 months. And you're gonna hear that she worked continuously during that time frame. She was a waitress, a server at 2 restaurants. For 2 years, lifting trays, carrying trays, doing the work that servers do. Absolutely no difficulty whatsoever. There is no claim for lost wages in this case. She did a good job. And you'll see some of the hours she worked. You heard about the avulsion or whatever procedure it was. You'll see the week that she had that done, she worked over 100 hours. 100 hours the week that she went in for this procedure was because she was in excruciating pain. And again, you'll see record after record after record on that particular matter. Now, let's talk about the course of treatment. Okay, she eventually ends up at Dr. Chung, who does this surgery. Dr. Chung, again, he was deposed. We wanted to know what he was going to say, so we weren't surprised when we came to the report. Dr. Chung didn't review any of her prior medical records. Not one. Dr. Grossman reviewed every single medical record that there is. The other thing is the plaintiff did tell us under oath that she had back pain not only after that accident that preceded our accident in 2008, but that she took ibuprofen for back pain all the way up until the time of our accident. From time to time, she would have back pain. Okay? And that's important because when they discharge her from the emergency room, they give her ibuprofen. You know, we talked about narcotic medication being prescribed. When she walked out of that emergency room, they gave her, they said, they didn't even give her prescriptions. They said, go take some Tylenol. And again, you ask yourself, if you listen to the evidence, if somebody has a completely numb back, they're gonna let you walk out of the emergency room, or they're gonna just tell you to not. But, so she goes to Dr. Chung, who doesn't have all the medical records. He does a procedure, and he claims it's all from this accident. Okay, and that's important. When you listen to this, they're claiming all of these problems are from the accident they're doctors. What's even more important is, two notes from, can you turn the Elmo on for me? She treats with Dr. Chung, and the surgery is done in May of 2012. You want to show them what depends on it? May of 2012 is when the surgery is done. The accident, remember, was in February 2010. 2 years and 2 months after the accident was done. She has the surgery. He releases her in 2013. She's doing well. There's no follow-up care for 4 years. 4 years. I want you to keep that in mind, that perspective. That's 4 Christmases, 4 Thanksgivings, 4 4th of Julys. You don't think back that far. Absolutely no medical care whatsoever. Back. And then what happens? And then what happens is 4 years with nobody seeing her. 4 years where there's no prescription medication. 4 years where she's taking ibuprofen like she did in the past for her back problem. Her attorneys find another doctor, Dr. Valero, and see her. Now, 4 years out now they find this doctor.
Objection, Your Honor, to the comment out of the blue.
Sustained.
I'll withdraw. For 4 years, nobody. And then Dr. Valero. How do we go from there? What's important to note is we deposed, again, this is right down the date. I know we're throwing a lot of dates at you, but August 28th of 2017, we deposed Dr. Valero. Put him under oath and said, please tell us the truth about everything you know in this case. And they just told you that Dr. Valero is going to come in and tell you that she needs surgery, further surgery as a result of this accident. I might just read it more. Okay. Technology is still a new like my kids use it. You help me out. So I can read along with it. Can you make that bigger? Because that's pretty bad. You may not do it like that. No. You sit here today, you don't know what her condition is. Answer, no. You don't know if she's at maximum mental improvement? No. Do you relate the complaints that she had to you to this accident 7 years before, or do you know? No, I don't know. I see the patient. I don't worry about the legal part. But that is not what you think happened here. You didn't think her back pain was from the surgery, so I don't know what the reason is for the sacroiliac joint. One of the reasons could be the accident, another reason could be the degenerative condition. But here's the thing that's important. I know I kind of breezed over that, but at the end of the case, this is the question you're going to have to answer. Did the plaintiff sustain a permanent injury within a reasonable degree of medical probability as a result of this accident? And this is Dr. Valero last year. You cannot tell me, what Mr. Bushman asked me this question, whether this accident did or did not cause her sacroiliac joint dysfunction, which is where the 3 bones were done.
Objection, Your Honor, misstatement of fact.
Right.
Because there are other causes for it, correct? The answer to this, as you already mentioned to me, is really subjective. In order to be objective, I can limit the sacroiliac joint. You don't know where it's coming from. That's their expert that they handpicked to come in and talk to you about causation. I don't know where it's coming from. So you can't tell me with a reasonable degree of medical probability if it's from her daily activities, if it's from her life history, if it's from her prior history or anything else. I can't. Let me take that down. Put this one up. Mark followed up again. You don't know if she has any permanent injury from the accident of 2010. Answer, no. No. Okay. So that's the issue. They have the burden of proof to prove to you that the procedure that was done 2 years and 2 months after this accident was caused by an accident that had a 7-mile-per-hour impact in emergency room or financial condition. That's really what this comes down to. Now, they intend to call Dr. Villaro in here on Wednesday. And we know from what we proposed that he has no opinions on permanent injury, on future medical bills, or causation, just all that. So let's see what he says. All right, and again, I mentioned this during my desire that the truth has to count for something. And hopefully it's really misspoken when you hear all the evidence. And it's all laid out for you. The decisions are pretty easy. Thank you.
Thank you, Mr. Robb. You all ready to call your first witness?
Gentlemen, before we do, maybe we have 5 minutes before we call our first witness out that procedure.
Yes, sir. All right. Arthur,
Just so
can we have, oh, well, are you going to step out? Well, let me have the jurors out in the hallway, please.
All right, for the jury, just leave your stuff there. So let's see what's on.
I thought you were setting up for your opening, or for your direct examination. What?
When you do, Your Honor.
Yes.
Your Honor, at this time, the plaintiff would move for mistrial due to individual comments and the aggregate comments made by defense counsel during his opening, including golden rule violations and comments made in contradiction of the court's motion in limine. The first I'd like to address is his comments that he made directly related to the letter of protection. He specifically told the jury, we know where that referral came from when he referred to the letter of protection. We can ask the court reporter to go back if the court's recollection requires. I objected to and reserved on a motion at that time out of respect for the jury and the court's time. But it is clear, as we discussed, that there is under Worley, under any case law, any reference to a referral, especially when we went over this, the timing of hiring a lawyer or anything with that respect was off limits. This seemed to be intentional conduct. It is in par with the conduct during his voir dire, where he went for there's a billing amount and a charged amount. In fact, out of respect to this court and Mr. Robb, we were told to file a motion in limine about his conduct in court and chose not to. Out of, again, respect for this court and Mr. Robb. I'm now second guessing myself for making that call. The second comment was, she goes to the ER and claims numbness in the back. They're not just going to let you out if you have numbness in your back with just ibuprofen. He didn't say her. He didn't direct it to Ms. Ruchimora. He said you. That was his second reference to them, as if their car had been repossessed. The bank would have been required to make them pay something. There are two comments that are clearly in contradiction to what's allowable. Clearly, I can't necessarily correct in the minds of the jury and are so far outside the bounds of what's allowable and what this court ruled upon.
The
Mr.
testimony
Robb.
in this case is going to be that the attorney, we have the chiropractor's testimony that we'll read, that Mr. Maldalone has referred 75 to 100 plaintiffs to his practice. What's the chiropractor's name, Mark? Yeah, Dr. Lusgard. So that's fair game, Judge. The bias of a particular chiropractor and an attorney, just like they're going to go after Dr. Grossman for the amount of times he's testified for us, that's fair game, Judge. It was proper comment on the evidence, okay? It also impeaches the plaintiff who says that the hospital absolutely sent her to the chiropractor. We know that's not true, Judge, because they didn't. Okay, we have the records from the hospital. As far as a golden rule argument, Judge, I never put the jury into the shoes of the plaintiff or the defendant.
I mean, I will say I didn't take it that way,
Yeah.
but I understand his concern because technically the way that it was worded could have been taken that way. Don't
Certainly
do that
wasn't my intention,
again.
Judge. Okay, absolutely. I mean, I said they
All right,
wouldn't
no,
let.
that's all right. I
they
mean,
wouldn't let you
I'm
walk out.
respectfully denying the motion for
On that
your
grounds,
motion.
how about the
Hey,
violation?
may I finish, Counselor?
on.
Just on that, Judge, and I just want to make sure the record's clear, it said they wouldn't let you walk out. You know, that's just a term. It wasn't like a hospital wouldn't let anybody walk out if they had a numb back. I mean, but again, you've already ruled on that, so I guess, what's your other ground?
I'll speak to the court. My issue, Your Honor, we discussed this issue and brought it up in the motion limit, that there should be no reference to the timing that an attorney was hired, and that you asked Mr. Robb, are you going to get into and claim and make it seem like there was a referral relationship or that the plaintiff referred to the chiropractor? You're like, I'm going to let you get into the letter of protection. I'm going to let you do that. He made no mention of the court. The first time the court and myself, because I'm second chair on this case, is hearing about this alleged referral relationship of 75 to 100 cases is right now. I can see it in the court's eyes. It was never brought up during the motion limiting. It was never brought up at any point before when he wanted to talk about what was inbounds and out of bounds. He let that just lie and brings it up right now. That is so inappropriate.
I'm sorry if counsel didn't read the depositions of their own treating doctors in this case, Judge. That certainly shouldn't fall back on me. It's clearly in there that the doctor, Mark Bushman, was there. The doctor said that this plaintiff's attorney has referred you 75 to 100 patients. The jury's going to hear that, okay? They are going to hear that testimony from us in this particular case.
And
So-
look what he did, Judge. He's now tying that general statement and a potential bias argument to create a referral relationship in this case without any evidence of it,
All
which
right.
is in complete contradiction.
Other than I have the chiropractor say.
Referral from whom to whom?
He's claiming
Talk to me. Referral from whom to
attorney
whom?
to chiropractor.
Well, is that what you're doing, Mr. Robb?
No, I'm just showing
I mean,
you.
I didn't see that. I didn't hear that, but I got to tell you, I understood it was from not, the lawyer was not involved. I didn't hear that.
I'd ask Madam Court Reporter then if she can go back. I objected and moved. I said, Judge, and I'm going to reserve on a motion. Contemporaneously, I don't want to let the jury know how that's affected me. That sends their mind racing. I've learned in my through my angst and general quick
All right.
response factor.
Here's what what I'm going to rule. Your motion is respectfully denied. I didn't take it that way. I didn't see it that way. However, Mr. Robb,
with it, Your Honor.
I want you to be very careful about crossing that line.
Judge, I am not going to cross that line. I'll give them my questions to their client. Ma'am, did you sign this the day you went to see it? Whose name is that, Doc? It's on the document that's coming in.
There are certain things that obviously you can ask about, but I don't want
Judge,
you.
I'm not going to make it a theme. I've been doing this for 30 years. I try cases all the time. I'm not going to cross that line. I know what I can do and not do in this case. Now, as long as you're bringing up motions, Judge, plaintiff's attorney spent a good portion, after liability's been admitted, they went and denigrated the defense, the fact that we filed an answer where we denied liability, that we denied requests for admissions. They filed a motion in limine that you granted this morning saying that failure to accept responsibility would not be something that they could bring up in this case. That's exactly what they did in their opening statement, basically painted her as somebody that's just not owning up to what she did. And
No,
that's why
because
they
what
did it.
happened was you all had brought up who, that it was, my recollection is that it was, I'm trying to remember the exact wording, something to the effect of that she admitted liability. That was not the situation. There was an order determining liability. That's, nobody is to go any further than we've already gone, and don't misrepresent either side the situation to the jury.
I understand, Judge, but their argument was, the reason we're here, there's 3 reasons. Number one, we had to file a lawsuit. This is her answer. She didn't own up to liability. We had to file a request for admission, so we had to file a motion with the court to get this admitted.
All right. The bottom line is the motions, bring the jury back in, let's get the witness on the witness stand, please. And we're only gonna go till about 5:30, 5:40, somewhere in that range, okay?
That's kind of right. Thank you.
Who's doing the direct examination?
Mr. Garcia?
Mr. Garcia?
However, Your Honor,
We're only gonna go for probably a half an hour.
okay, we're going to be calling Ms. Grullon.
Yes. Oh, Ms. Grullon, first.
And
Okay.
in an abundance of caution, make sure that, in case she doesn't show up tomorrow.
Okay.
She'll be here the whole trial, Judge. There's no one else to do.
They went to the bathroom? All right. One of the jurors went to the bathroom, so we have a couple more minutes.
Okay, I just need to grab for my documents.
Well, I tell you what, both sides talk. If you tell me, Mr. Rob, that she is going to be here tomorrow,
She will be here tomorrow.
and you're telling the opposing counsel that she will be here tomorrow, then I leave it to you all to do whatever you want.
I plan on having her here for the entire trial, Judge. I don't like sitting in trial by myself. Mr. Bushman is good company as he is. I'm sure he wishes he was somewhere else. Or with someone else.
Want anything pre-marked?
We have remarked the
One
medical
for
bill charges and the medical bills.
Those aren't going.
They go through.
All right. So wait. So who is it? Is it? Are you calling your client or Miss Grullon?
We're going to call our client.
Okay.
Ms. Sompun, Ruchimora.
Okay. Thanks.
You ready? Okay, come in. Go. All right, so the jury, please.
Please be seated.
All right. All of the jurors are present. Mr. Garcia, you ready to put your first witness on?
We are, Your Honor.
All right. Please.
The plaintiff calls Ms. Sompun Ruchimora to the stand.
this way.
All right, ladies and gentlemen of the jury, just so you know, for planning purposes, we're probably going to go maybe a half an hour longer today from here till about 5:45, and then we'll recess, come back into court tomorrow morning at about 10:15, 10:20. Okay? But we're going to stay late tomorrow. All right? That meeting around 7. So let's make sure you make plans ahead of time, okay? All right, please.
Interpreter, do you swear or affirm that you will faithfully and truly interpret from English to Thai and Thai to English, and that you have the knowledge and ability to so do?
Yes, I do.
Thank you. Could you raise your right hand, ma'am? Do you swear or affirm that the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
You got to go through the interpreter.
You have to go. Okay.
ค่ะให้สาบานตัวนะคะว่าทั้งหมดที่จะให้การนั้นจะมีแต่ความจริงเท่านั้นจะไม่มีอะไรนอกเหนือไปจากความจริงเลย Yes, I do.
Thank you. Have a seat.
No, no, I'm not.
I'm going to get you a chair.
You want a chair?
No, I'm fine. Yeah.
Just in case you want.
Let's go.
Okay.
Look, we got it. She's got it. Art.
Sorry if I'm blocked. I'm trying to set up so I can see you all and you can see me.
Oh, I got it first.
Okay.
Thank you.
Mr. Ruchimora, could you please introduce yourself to the jury?
คุณติ๋วแนะนำตัวเองให้กับคณะลูกคุณเลยจากสุภาพค่ะ สมพันธ์รุจิโมระค่ะ My name is สมพันธ์รุจิโมระ
And Ms. Ruchimora, you can sit during your testimony. It'll be easier.
นั่งลงได้นะคะในระหว่างที่จะพูดนะคะ
Could you tell the jury how old you are?
อายุเท่าไหร่คะ
65
65
And where do you live?
คุณอาศัยที่ไหนคะ
Pompano Beach
คอมพาโนบีช
How long have you lived in South Florida?
อยู่ที่ฟลอริดาตอนใต้นี่มานานเท่าไหร่แล้วคะ
ประมาณ35 ปีค่ะ
approximately 35 years
And Ms. Ruchimora, we're using a Thai interpreter today. Do you actually understand English?
การถึงแม้ว่าเราจะต้องใช้ล่ามนะคะคุณสมพันธ์เข้าใจภาษาอังกฤษบ้างไหมคะ
บ้างค่ะ เข้าใจบ้าง
Yes I do understand some
Can you explain to the jury why you prefer to use a Thai interpreter during the question?
ช่วยเล่าให้ผู้คุณฟังหน่อยได้ไหมคะว่าทำไมถึงอยากจะให้มีล่ามมากกว่าที่จะไม่มีล่าม
เพราะว่าภาษาอังกฤษไม่สมบูรณ์นะคะ
because my English is not complete
Are you married?
คุณแต่งงานหรือเปล่าคะ
ตอนนี้ไม่ค่ะดีวอร์ดค่ะ
I went through a divorce
And do you have any children?
มีลูกไหมคะ
คนหนึ่งค่ะ
Yes I have one
Ms. Ruchimora, I'm going to ask you some questions about the crash that we're here on today. Do you recall the date of the crash?
ทนายของคุณจะถามถึงเรื่องอุบัติเหตุที่เกิดขึ้นนะคะคุณจำอะไรได้บ้างคะในเรื่องอุบัติเหตุที่เกิด
วันที่ 26 กุมภาพันธ์
It was February 26
2010
2010
And do you remember what day of the week it was?
จำได้ไหมคะว่ามันเป็นวันอะไร
Friday วันศุกร์ค่ะ
It was Friday
And around what time of day did the crash occur?
เพราะเกิดเหตุเนี่ยประมาณเวลาเท่าไหร่คะ
ประมาณ4:15 ถึง4:30นะคะ
It's approximately 4:15 to 4:30 ตอนเย็นเหรอคะ
ตอนเย็น
PM
And can you tell the jury where you were going that day?
บอกได้ไหมคะว่าตอนนั้นเนี่ยคุณกำลังจะไปไหน
จะไปทำงานค่ะ
I am on my way to work
And where were you coming from?
มาจากไหนคะ
มาจากบ้านค่ะ
From home
จากทางโน้ตจะไปทำงานที่ไมอามี่ค่ะ
I left my home in the north and heading to Miami
Can you tell the jury what kind of car you were driving that day?
ตอนนั้นขับรถอะไรคะ
เชฟโรเล่ค่ะ
Chevrolet
And,
SSR
SSR
and did you have any passengers in the car with you?
ในรถวันนั้นมีผู้โดยสารนั่งไปด้วยไหมคะ
ไม่มีค่ะ
No
And what road were you on and which direction were you headed?
คุณอยู่บนถนนอะไรแล้วก็มุ่งหน้าไปทางไหนคะ
อยู่บน95ค่ะ I-95 จะไปเซาท์
I was on I-95 heading south
ค่ะ เตรียมตัวจะออกที่ไมอามี่การ์เด้นค่ะ
I am preparing to exit at Miami Garden
And how was the weather that day?
อากาศเป็นไงคะตอนนั้น
อากาศดีค่ะ
Fair good weather
And the traffic that day, how was the traffic?
แล้วการจราจรเป็นยังไงคะ
การจราจรปกติค่ะธรรมดา
normal
What lane were you in on I-95 southbound?
ตอนที่คุณมุ่งหน้าไปทางใต้บน I-95 เนี่ยนะคะคุณอยู่บนช่องทางไหนคะช่องทางที่เท่าไหร่บนถนน
ขวามือค่ะ
I was on the right lane
Now, you stated that you were intending to exit at Miami Gardens. Did you have a return signal on?
คุณบอกว่าคุณกำลังจะเตรียมตัวที่จะออก exit ที่ Miami Garden ใช่ไหมคะเปิดสัญญาณไฟเลี้ยวหรือเปล่าคะ
เปิดค่ะ
Yes I did
And as you were approaching the exit to Miami Gardens, can you tell the jury what happened with the traffic?
ในขณะที่คุณกำลังมุ่งหน้าที่จะไปออกทางออกที่จะไป Miami Garden เนี่ยมันเกิดอะไรขึ้นคะ
เปิดสัญญาณไฟใช่ไหมคะจะออก
I turned the signal I turned the signal
ค่ะ
on
แล้วรถก็เราก็ลดช้าลง
and I slow my vehicle
ค่ะ แล้วก็ถึงกระสินจะเกิดถึงจะเขาจะมาชนข้างหลัง
and fell someone hit me in the rear
Okay. And why did you slow your vehicle as you were approaching the exit?
แล้วทำไมถึงต้องช้าลงนะคะในขณะที่
เพราะว่าเราจะออกนะเราใกล้จะออก exit แล้วนะคะ
because I was almost approach the exit
And was the traffic in front of you, was it moving at a normal pace or was it slowing down?
แล้วก็การจราจรที่อยู่ข้างหน้านะคะรถที่อยู่ข้างหน้าเนี่ยวิ่งช้ากว่าปกติหรือว่าวิ่งปกติ
วิ่งปกติค่ะ
normal
Okay. Did the traffic ahead of you slow down?
การคนที่ขับอยู่ข้างหน้าการจราจรข้างหน้าเนี่ยทุกคนต่างก็ชะลอลงหรือเปล่าคะ
ใช่ค่ะ
yes
And when you were hit from behind, was your car moving or were you at a stop?
ขณะที่รถถูกชนเนี่ยนะคะรถคุณกำลังเคลื่อนที่อยู่หรือรถคุณจอด
ชนแล้วจอดค่ะรถมันดับ
after I was hit the car stopped because the engine was shut down
But at the time that you were hit, were you still moving or had your car come to a complete stop before the impact?
ขณะที่เกิดเหตุนะคะขณะที่ถูกชนนะคะรถของคุณเนี่ยกำลังวิ่งอยู่รถกำลังจอด
กำลังวิ่งค่ะ
run
When you say running, do you mean that your car was still moving slowly or was your car stopped when you were hit?
ตอนที่บอกว่าวิ่งเนี่ยนะคะหมายความว่ารถเนี่ยกำลังเคลื่อนที่ไปช้าๆหรือว่าจอดหยุดสนิท
เคลื่อนที่ไปช้า
moving slowly
Okay. Were you wearing your seatbelt?
คุณใส่เข็มขัดนิรภัยหรือเปล่าคะ
ๆใช่ค่ะ
yes I did
And when you were hit from behind, what happened to your car?
แล้วพอถูกชนข้างหลังแล้วเกิดอะไรขึ้นกับรถคุณคะ
พอรถมันดับนะคะ เครื่องมันดับแล้วเขาก็มาฮิตอีกทีหนึง
the engine was shut down and then I felt another crash
When you were first impacted, was your car pushed forwards?
ตอนที่ถูกชนครั้งที่หนึ่งเนี่ยนะคะรถเนี่ยถูกผลักไปข้างหน้าหรือเปล่าคะ
ใช่ค่ะ
yes it was
Did you hit any cars ahead of you?
แล้วก็คุณไปชนรถข้างหน้าหรือเปล่าคะ
ไม่
no
Okay. Were there cars ahead of you?
มีรถอยู่ข้างหน้าไหมคะ
รถเขาก็เขาเลื่อนไปแล้วค่ะรถเขาวิ่งไปธรรมดา
they all move away normal
What part of your vehicle was hit?
แล้วรถของคุณเนี่ยถูกชนตรงส่วนไหนคะ
ข้างหลังค่ะ
the rear
And could you describe the impact for the jury?
แล้วก็อธิบายได้ไหมคะว่าเนี่ยมาชนแล้วเนี่ยมันรถของคุณเนี่ยมีถูกถูกชนเสียหายบ้างไหม
เวลามันชนใช่ไหมคะ แล้วมันก็มีอะไรเนี่ยตรงเนี้ยแบบบัมเปอร์หรืออะไรมันก็บุกเข้าไป
the something that I consider to call it bumper was a dent in
Okay. Now, I just want to ask you about the impact first. Would you describe the impact as light, medium, or heavy?
การชนเนี่ยนะคะรุนแรงแค่ไหน
ปีระหว่างมีกลางจนถึงเยอะ
medium to high
What happened to your body when you felt the impact?
แล้วตอนที่ถูกกระแทกปุ๊บเนี่ยตัวคุณรู้สึกยังไงคะ
ชาข้างหลัง
numb on my back
ชาแล้วเราก็แบบอันนี้ไม่ได้ จะหันมาดูนะหันไม่ได้
I was numb that I could not turn คุณให้ปากคำอยู่ภายใต้คำสาบานนะคะ
ค่ะ
yes
Did you state that your vehicle was a total loss, or did you state that you had some moderate damage to your vehicle?
ตอนที่คุณให้ปากคำเนี่ยคุณบอกว่ารถของคุณเนี่ยพังเสียหายโดยสิ้นเชิงหรือว่ารถของคุณเสียหายมาก
เสียหายเท่าที่ความจริงมันเป็นนะคะก็บอกเท่าที่รถมันเป็นนะคะ
In the deposition I told just as much damage that I got that was on my car
Okay, and what was that damage that you described in your deposition?
แล้วก็ตอนที่ไปให้ปากคำเนี่ยนะคะบอกว่าความเสียหายของรถเนี่ยเป็นยังไงคะจำได้
ความเสียหายของรถก็พูดก็เหมือนกันนะคือพูดตามความจริงนะคะไม่รู้จะพูดยังไง
I just told them the truth about the damage to my car whatever it was
เพราะว่าตำรวจนะเขาอยู่ตรงนั้นเราก็เลยอุ่นใจนะ
The reason was that I saw a policeman came to me so I felt confident that someone will help me
Was your car drivable after the crash?
พอหลังจากเกิดเหตุแล้วเนี่ยรถยังขับได้อีกไหมคะ
ขับ ได้
yes
Now, you mentioned that your back was numb. Where did you go after the accident?
คุณบอกว่าที่หลังของคุณเนี่ยก็ชาใช่ไหมคะแล้วพอเกิดอุบัติเหตุแล้วคุณไปไหนเพราะว่าหลังเนี่ยชาแล้วคุณไปไหนต่อ
ขับไปโรงพยาบาลค่ะ
I drove to the hospital
Okay. And which hospital did you drive to?
ไปโรงพยาบาลไหนครับ
นอร์ทแมมี่ค่ะแจ็คสันฮอล
Jackson North มาเอง
And did you go to the emergency room?
ไปที่ห้องฉุกเฉินหรือเปล่าครับ
ใช่ค่ะ
yes
And where did you tell them you were hurt?
แล้วตอนที่เข้าไปในห้องฉุกเฉินแล้วบอกเขาว่าเจ็บที่ไหนครับ
ตอนนั้นเจ็บหลังค่ะหลังแล้วก็เนี่ยไหล่
back and shoulder
แล้วก็คอ
and neck
คอมันฮิตกับกระจกก็ไปฮิตกัน
because my neck hit the mirror
หน้าต่าง
window hit the window
When you say the window, do you mean the driver's side window next to you or the windshield?
หมายถึงกระจกข้างนี้นะคะกระจกหน้าต่างรถนี้หรือว่าก
ระจกหน้าต่าง
the side window
At the hospital, what did they do for you?
แล้วที่โรงพยาบาลเขาทำอะไรให้คุณครับ
เขาเอ็กซเรย์ค่ะ
they took an x-ray
เอ็กซเรย์แล้วก็ให้ยาแก้ปวด
and gave me some painkiller
Did you follow up with any doctors?
แล้วก็มีการไปหาหมออื่นต่อเนื่องต่อไปไหมครับ
ตอนนั้น2-3 วันก็ไม่ได้ไปค่ะแล้วก็เขาก็ให้ไปหาหมอที่หมอนวดนะคะ
The first 2-3 days I did not and then I was referred to massage doctor
หมอนวด
in Thai we call massage doctor
Would that be a chiropractor?
ไคโรแพคเตอร์ใช่
chiropractor
Now, you stated you were referred to the chiropractor. Do you know who referred you?
บอกว่าต้องถูกส่งไปหา chiropractor นะคะคือหมอจับเส้นนะคะจำได้ไหมคะว่าใครเป็นคนส่งไป
หมอค่ะหมอเขาคุยค่ะ
doctor told me
Okay. Did the doctor at the hospital tell you to follow up with a physician?
แล้วคุณหมอที่โรงพยาบาลเนี่ยบอกว่าให้มาติดตามต่อไปอีกด้วยหรือเปล่าคะ
ใช่ค่ะ
yes
When you went to the chiropractor, what were your complaints at that time?
แล้วตอนที่ไปหาหมอจับเส้นนะคะที่เรียก chiropractor นะคะไปบอกหมอจับเส้นเนี่ยว่าเป็นยังไงครับไปบอกเขาเลย
ก็บอกว่าตอนนั้นปวดหัวแล้วก็ไหล่เนี่ยไหล่คออะไรก็บอกเขาทุกสิ่งที่เราเจอค่ะ
At the time I told him that I had headache pain and neck pain
And what about your back?
แล้วหลังนะคะ
แบ็คด้วยค่ะ
also my back
Okay. And what did the chiropractor do for you?
แล้วหมอจับเส้น chiropractor ก็ทำอะไรให้คะ
เขาก็ให้ทำเป็นเอ็กซ์ไซส์แล้วก็ใช้เขาเรียกอะไรที่มันเจาะเป็นไฟฟ้านะคะเป็นเครื่องไฟฟ้า
She gave me some exercises and used some electrical thing
แล้วก็นวด
to massage me
So did they provide therapy? Is that what they did?
บำบัดใช่ไหมคะ
ใช่ค่ะ
yes
And how often were you going for therapy at the chiropractor?
ไปบำบัดบ่อยแค่ไหนคะกับ chiropractor
3 วันตอนนั้นนะคะ
3 days a week
Did the therapy help?
แล้วการบำบัดช่วยไหมคะ
มันก็ช่วยนะคะก็ใช้เวลา
yes it did but it took time
Okay. Did it take the pain completely away?
แล้วก็การเจ็บปวดเนี่ยการปวดการอะไรเนี่ยหายไปเลยไหมครับ
ไม่หายเลยค่ะ มันจะค่อยๆหายแล้วเขาก็จะให้ไปแบบจาก3ต่ออาทิตย์ใช่ไหมคะก็เหลือ2เหลือ1
the pain decreased and then the appointment decreased also from 3 days a week down to 2 and then 1 per week
Did they send you for any diagnostic tests?
แล้วก็ได้ส่งไปให้มีการหาข้อมูลหา diagnostic ไปตรวจสอบอะไรที่อื่นต่อไหมคะ
มีค่ะ
yes
And what kind of diagnostic tests did they send you to or recommend?
เขาแนะนำให้ไปตรวจแบบไหนที่ไหนคะ
ตอนจำไม่ได้มันเป็นหลายหมอมากเลยอะ
I went to see so many doctors. I cannot
จำไม่ได้
remember all of them right now.
Okay. Did they send you for an MRI?
ไปทำ MRI หรือเปล่าคะ
ใช่
Yes it
And what part of your body did they do the MRI on?
ตอนที่ไปทำ MRI เขาดูส่วนไหนของร่างกายคะ
ดูที่หลังค่ะ
My back
Okay. Would that be your lower back, your middle back, or your upper back?
ส่วนไหนของหลังคะตอนบนตอนกลางตอนล่าง
น่าจะตรงเนี้ย
I don't know somewhere
Okay. You're indicating your lower back.
ยากมันระหว่างมันอยู่ในระหว่าง
in between
ที่ตรงไหนที่เราเจ็บอะเราก็บอกเขาอะ
wherever I have pain I told them
Did you ever find out what the MRI showed?
แล้วรู้ไหมคะว่าผล MRI ออกมาว่ายังไง
Judge, it's all hearsay.
เขาก็บอกว่า
Judge, on this.
Judge, objection hearsay.
All right. I'm asking her whether she knows about her MRI results. It's part of her treatment, Your Honor.
Well, it may be part of her treatment, but that's coming through, in through the doctor. So please.
Your Honor, it also goes to effect on listener.
That's not relevant at this point, so what's your next question, please?
As a result of the MRI, were you sent for any additional treatment to another doctor?
หลังจากได้ผล MRI แล้วเนี่ยนะคะถูกส่งไปหาหมอคนอื่นอีกหรือเปล่าคะ
ส่งค่ะ
Yes
Okay. And what type of treatment were you sent for?
หลังจากที่ MRI แล้วเนี่ยนะคะหมอแบบไหนที่เป็น
เขาก็แนะนำให้ผ่าเขาบอกว่าแบบกระดูกมันไม่ตรง
I got some instruction that I need a surgery because some part of the bone is not lining up.
Did you decide to have surgery at that point?
แล้วตอนนั้นตัดสินใจผ่าไหมคะ
ไม่
No.
Did they give you any alternatives, some other treatment instead of the surgery?
ถ้าหากว่าแล้วหมอให้เงื่อนไขอื่นไหมคะว่าถ้าไม่ผ่าเนี่ยทำอะไรได้อย่างอื่นบ้างได้บ้างไหม
ฉีดยาเข้าหลังค่ะ
Some shot into the back, right direct into my back.
Can you explain to the jury why you chose not to have surgery the first time a doctor recommended it?
อธิบายให้ลูกคุณฟังหน่อยได้ไหมคะว่าตอนหมอแนะนำบอกให้ผ่าทำไมถึงไม่ผ่าตอนนั้น
กลัวค่ะกลัวด้วยแล้วก็เราอยู่คนเดียวเราไม่มีคนดูแล
I was so scared because at the time I was living all by myself alone. If after the surgery, how can I take care of even myself?
Had you ever had surgery before aside from childbirth?
นอกจากการคลอดลูกแล้วเนี่ยนะคะเคยมีการผ่าตัดอะไรอย่างนี้ไหม Never.
Let's get back to the injections. Did the injections that you received on your lower back, did they help?
กลับไปที่การฉีดยานะคะ การฉีดยาที่ฉีดเข้าไปที่หลังเนี่ยช่วยไหมคะ
ช่วยค่ะแต่ไม่นาน
Yes, for a short period of time.
And what happened after that short period of time?
แล้วไม่นานแล้วเกิดอะไรขึ้นอีกคะหลังจากที่ฉีดแล้วก็ดีขึ้นไม่นาน
ก็กลับไปหาหมอใหม่
I went back to see the doctor.
And what did the doctor tell you?
แล้วหมอว่าไงคะทีนี้
Objection hearsay, Your Honor.
Sustained.
ก็
What was the next course of treatment that was recommended to you?
แล้วก็การบำบัดครั้งต่อไปในการรักษาต่อไปเนี่ยนะคะที่ได้รับคำแนะนำเนี่ยคืออะไรคะ
คือให้ผ่าตัดอีกทีจะให้ผ่าตัดอีกก็เลยต้องยอมเพราะมันปวด
Another surgery option came up.
Do you remember the name of the doctor who recommended surgery the second time?
หมอที่แนะนำเป็นหมอที่สองก็ต้องผ่าเนี่ยชื่อหมออะไรคะ
ดรชัง
Dr. Chang.
And did you agree to have the surgery done?
แล้วก็ตกลงผ่าค่ะ
ผ่าค่ะ
Finally I did.
And once you had the surgery, did it help?
หลังจากผ่าแล้วเนี่ยมันช่วยไหมคะ
มาถึงเสร็จหายเรียบร้อยแล้ว แต่ตอนผ่านั้นมันแย่มากเลยอ่ะแล้วก็หลังจากนั้นมันก็ช่วยค่ะ
During the operation it was so bad, but but after the surgery I got better.
3 เดือน 4 เดือนให้หลัง
About 3 to 4 months after the surgery.
How many days did you spend in the hospital after the surgery?
ในขณะที่ผ่าตัดเนี่ยนะคะอยู่โรงพยาบาลกี่วันคะ
5 วันค่ะ
5 days
Now, prior to the surgery, aside from the pain in your back, did you have pain running down your legs?
ก่อนที่จะผ่าตัดเนี่ยนะคะนอกเหนือไปจากที่เจ็บหลังแล้วเนี่ยนะคะมันเจ็บลงไปที่เท้าด้วยหรือเปล่าคะ
เจ็บด้วยค่ะ
Yes it went down
Did the surgery resolve that pain that was running down your legs?
แล้วก็พอผ่าตัดแล้วเนี่ยนะคะไอ้การที่เจ็บลงไปที่เท้าเนี่ยที่ขาเนี่ยมันช่วยไหมคะหายไหมคะจากการผ่าตัด
ช่วยค่ะมันก็ค่อยๆลดน้อยลง
Yes slowly it decreased the pain
After the surgery, do you have any continuing pain after the surgery?
หลังจากที่ผ่าตัดแล้วเนี่ยนะคะยังมีการเจ็บปวดต่อยังมีการเจ็บต่อเนื่องไหมคะมีการปวดต่อเนื่องไหมคะ
พักใหญ่อะนานเหมือนกัน มันก็เจ็บมันเหมือนมีอะไรเหน็บอยู่อะ
For a long time I felt like something attached to what เหน็บตรงไหน
เหมือนเหน็บลงไปตรงข้างสะโพกเนี่ย
attached down from my hip
And did you tell the doctor about this continuing pain in your hip?
แล้วบอกหมอหรือเปล่าเพราะว่าเนี่ยไอ้ตรงเนี้ยมีเจ็บมีปวดมีอะไรตรง
ค่ะกลับไปหาหมอ
Yes I went back to the doctor
And what is your understanding about the pain in your hip? Is it something that could be fixed, or were you something you had to live with?
แล้วรู้ไหมคะว่าเนี่ยไอ้ที่มันมีปวดตรงสะโพกเนี่ยนะคะมันแก้ไขได้มันซ่อมได้มันรักษาได้ หรือว่าจะต้องเป็นกับเราไปชั่วชีวิต
ครั้งแรกคิดว่าหมอเขาอยู่มาแล้วไว้ในนั้นนะเราความรู้สึกแบบนั้นจริง
The first time I thought the surgeon left some tool inside I really feel that
Did the surgeon leave a tool inside?
เขาทิ้งอะไรไว้หรือเปล่าคะ No nothing
And what was your understanding about that continuing pain? Was it something that the doctor could fix, or was it something that you were going to have to live with?
แล้วตอนที่พอเจ็บเนี่ยนะคะแล้วคิดว่าหมอจะรักษาได้หรือว่าต้องอยู่กับมันไปจนตายเนี่ย
ๆครั้งแรกที่กลับไปหาหมอเพราะนึกว่าหมอรักษาได้ แต่เสร็จแล้วหมอบอกว่า no มันจะอยู่อย่างนั้นนะ
The first time that I got that pain, I felt that pain, I went back to the doctor because I hope that the doctor will tell me that yes, it's going to be healable. But no, the answer was not what I expected. The doctor told me I have to live with it.
Now, 4 years later, you were sent to see Dr. Valerio. Is that correct? Another orthopedic surgeon?
หลังจากที่เกิดอุบัติเหตุมาแล้ว 4 ปีเนี่ยนะคะ ก็ถูกส่งไปหาหมอ What is the doctor's name?
Valerio?
หมอวอร์เรียล
ใช่ เพราะมันปวด
Yes, because the pain came back.
เพราะว่าบางทีเราทำงานในบ้านหรือยืนทำอาหารอะไรแบบนี้พอยืนนานๆแล้วมันก็ไม่ไหวอะปวด
Because even I am working around the house, like I'm cooking in my kitchen, the pain came back that I could not bear that anymore.
When you went to see Dr. Valerio, were you recommended another course of treatment?
แล้วตอนที่ไปหาหมอวาราริโอเนี่ยนะคะหมอวาราริโอแนะนำการรักษาการบำบัดอะไรอีกไหมคะ
เขาก็ฉีดใหม่
Another shot.
Okay. Was surgery recommended?
มีการแนะนำให้ผ่าอีกไหมคะ
ไม่เราไม่ยอมผ่า
Because I won't allow to.
แต่แล้วเราจะระวังตัวเองที่จะไม่ให้มันปวดอะเราก็ไม่ทำงานหนักไม่ยกของหนักอะไรแบบนี้
And I try to take care of myself by not lift heavy thing, not stand for too long, try to keep myself away from the cause of the pain.
Okay. Now, I understand that you didn't choose to have surgery, but was surgery recommended?
เข้าใจนะคะว่าไม่เลือกที่จะผ่าแต่หมอแนะนำให้ผ่าหรือเปล่าคะ
ครั้งที่ 2ใช่ค่ะหมอแนะนำแต่เราไม่เอา
Yes, when I went to see the doctor the second time, the doctor suggests, but I declined.
Okay. And did you do anything instead of the surgery?
แล้วก็เมื่อไม่ผ่าแล้วทำอะไรกันทำอะไรบ้างครับ
ก็แค่ฉีดนะคะแค่ฉีดหลังสุดก็ฉีด
shots
And did those shots help?
แล้วก็ไอ้ฉีดเข้าไปเนี่ยช่วยไหมคะ
มันก็ช่วยค่ะแต่ถ้าเราระวังไม่ยกของหนักมันก็จะนาน แต่ถ้าไม่ระวังมันก็เป็น
The shot help for a short period of time, but if I did not take good care of myself, I don't lift everything or don't stand or do something for too long, the pain came back sooner.
Do you still have pain today?
วันนี้ยังปวดไหมคะ
นิดเลยนิดหน่อย
A little bit of that.
Okay. And describe to the jury the pain that you still feel today.
และลองอธิบายให้ฟังสิคะว่าขณะนี้ปวดยังไงปวดตรงไหน
ปวดเพราะว่าเรารัดที่รัดไว้อะนะที่รัด
I have the belt on,
ไม่ใช่เบลอะไรนะเขาเรียก
support,
ซัพพอร์ต
the support belt on.
Okay. But can you describe to the jury the kind of pain that you have today?
อธิบายถึงอาการปวดวันนี้ที่รู้สึก
เมื่อกี้ทานยาแล้ว
I just took a pill.
อาจจะ
When you do feel pain, can you describe the pain to the jury?
ลองอธิบายใช่ไหมหน่อยสิคะว่าเวลาปวดเนี่ยมันปวดยังไงปวดตรงไหนปวดแบบไหน
ปวดแบบเวลาเรานั่งนานใช่ไหมหรือที่นั่งไม่ดีเนี่ยเหมือนตอนขับรถน่ะก็ต้องใช้หมอนเพราะว่าถ้าที่นั่งถ้ามันตรงแบบเนี้ยโอเค แต่ถ้ามันเอียงอย่างเงี้ยไม่ได้
When I sit on a unlevel seat, like in my car, I have to put a support cushion to support myself to make the seat level. The unlevel will cause a lot of pain.
Can you give some examples to the jury of the types of things that you do that cause you to have pain?
ลองยกตัวอย่างสิคะว่านอกจากที่นั่งไม่ดีนั่งเอียงแล้วเนี่ยอะไรอีกที่เราทำแล้วก็เจ็บทำแล้วก็ทำให้เกิดความเจ็บ
เดินเยอะ
When I walk too much,
กับของหนัก
lift heavy stuff,
เราต้องพยายามที่จะไม่ยก
I try to avoid not to lift heavy things.
หรือไม่ก็อย่างจะเดินออกกำลังกายเนี้ยไม่ได้
Or when I want to walk for an exercise, I could not do that.
And you mentioned that you took a pill today. Can you tell the jury how you deal with the pain when you do have pain?
แล้วเมื่อกี้วันนี้ก็กินยาใช่ไหมคะแล้วปกติเนี่ยถ้าปวดเนี่ยทำไง
ก็กินยา
ทุกกระเพี้ยว
Do you belong to a community center?
เป็นสมาชิกของสมาคมอะไรใช่ไหมคะ
ใช่ค่ะไปเยี่ยมอ่ะใช่
Yes, I do. I socialize with some community service center.
Okay. And you previously testified you live in Pompano. Where's the community center that you attend?
เมื่อกี้บอกว่าบ้านอยู่พัมพันโนบีใช่ไหมคะ แล้วก็ไอสมาคมที่ไปสมาคมด้วยเนี่ยอยู่ที่ไหนคะ
โฮมสเตย์อินไมอามี่
Homestead South Miami.
Okay. And is this a Thai community center?
เป็นศูนย์คนไทยใช่ไหมคะ
ใช่ค่ะ
Yes.
Is that the closest one to you?
อันนี้อยู่ใกล้ที่สุดหรือเปล่าคะ
นี่อันเดียว
It's only one.
Okay. And how long does it take you to drive from Pompano down to the Thai Community Center in Homestead?
ขับรถจากบ้านที่พัมพันโนไปโฮมสเตย์ใช้เวลานานเท่าไหร่คะ
ประมาณ1 ชั่วโมงกับประมาณ20 นาที
About 1 hour and 20 minutes.
And how do you get to the community center?
แล้วไปได้ยังไงคะ
ไปได้ยังไงรู้จักได้ยังไงเหรอคะ
How I know them?
No, how do you get to the community center?
เวลาไปยังไง
ขับรถ
Drive.
ขับรถ
And you already testified that you use a pillow when you drive. Is that correct?
เมื่อกี้นี่บอกว่าเวลาจะขับรถเนี่ยต้องเอาหมอนรองนั่งใช่ไหมครับ Yes.
And why do you need to use a pillow when you drive those long distances?
ทำไมเวลาขับรถไปทางไกลๆเนี่ยเอาหมอนต้องเอาหมอน
ต้องเอา
ใส่
หมอนเพราะว่ารถมันไม่ได้ตรงแบบนี้มันจะเอียง
Because the seat, the driver's seat is not level.
And because it's not level, does it cause you any pain?
ก็เพราะมันเอียงเนี่ยทำให้เจ็บ
ใช่ต้องเอาหนุนให้มันเสมอกัน
Yes, I have to make it level.
I'm going to show you what's previously been marked for identification as plaintiff's 1 and ask you if you recognize what this document is.
ให้ดูเอกสารนะคะจำเอกสารนี้ได้ไหมคะ
ได้ค่ะ
Yes, I recognize.
Okay, and what is it, can you describe to the jury what that is?
บอกอธิบายให้ลูกขุนฟังได้ไหมคะว่านี่มันคืออะไร
เป็นการรักษาค่ะค่ารักษา
My treatment bill
Okay. And are those your medical bills for the treatment that you received as a result of this accident, this crash?
อันนี้เนี่ยเป็นค่ารักษาจากอุบัติเหตุที่เกิด
ได้ค่ะ
Yes
Okay. And can you tell the jury the total amount of your medical bills as a result of this crash?
ยอดเท่าไหร่ครับ
367,547 and 60 cents.
May I read that
Of course.
Which one 367,547.60
And attached, Your Honor, I'd like to move in the medical bill charges and the medical bills into evidence.
We have an objection to that, Judge. It's going to take some argument, so we object to it moving in, object to it being used at all.
All right, I'll tell you what I'm going to do. Rather than keep the jury around while we do that, I want everybody sticking around. I'm going to excuse the jury for the evening because it's almost 10 till 6. Don't forget, tomorrow morning, 10:15 on the second floor. They'll go back to the jury room on the second floor, and Arthur will pick you up there on the second floor, all right? Leave your notebooks here. We're going to go till, anybody, is there any serious issue that you all have if we, I mean, it doesn't get dark till 8 o'clock, or the sun doesn't set till around 8 o'clock, okay? I do want to keep you until 7, probably 2 nights in a row, however, so we can get done this week. Is there an issue that any of you have that I can help with in that regard? Not with your spouses, I can't help that, you know. But are we all okay in that regard if we go till 7? It's going to be 10:30 till 7, Tuesday and Wednesday, and then we'll talk about Thursday as we get there, okay? Great. Thank you all. All right. We'll see you tomorrow morning on the second floor. Arthur will see you at 10:15 a.m.